you are ready, we can go live.
Moment. Okay. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Single Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, Mr. Conley, and welcome everyone to the Massachusetts Appeals Court on this January 19th, 2022. I'm Justice Joseph Ditkoff, and I will be the single justice presiding over the hearings today. The first, and I should say that in accordance with the directives from Chief Justice Budd and Chief Justice Green, we are holding these hearings by Zoom virtually, but we are being live broadcast on our YouTube channel. And I want to welcome anyone who is watching on the YouTube channel. You're very welcome. The first case today is 21 Gilbert Street, LLC versus Rogers, number 21J 623. With us is Mr. Rogers, the counsel for the landlord. This is on, I should say, a request for extra fees and costs under Chapter 261. It is not evident to me that the landlord has any standing to oppose Mr. Rogers' request for extra fees and costs, but in any event, he was invited to this hearing and he declined to participate. So it will just be Mr. Rogers at this hearing.
Thank you.
So that is where we stand. Mr. Rogers, you filed a brief, which I received yesterday and I read carefully. And there were sort of three questions you had, or comments perhaps. The first was you wanted the reasoning behind my affirmance of Judge Winnick's earlier order. And I gave my reasoning in the January 4th, 2022 order. And I'm afraid that that is the reasoning I have for that decision. The second thing was you suggested the trial court has failed to dispose of post-judgment motions that were holding up under Mass Rule of Appellate Procedure 4 in a timely fashion. I looked at the transcript pretty carefully, the docket I mean, and I saw that on July 23rd, 2021, you filed a Rule 60 motion. It was scheduled for August 3rd. It was continued at your request. There was a hearing on August 17th, and the motion was denied on August 19th. It may not appear that way to you, but that is actually pretty prompt for our system. And the third thing is you suggested there were repeated failures to respond to your requests for a waiver on the cost of transcripts and recording. Now, I could be missing things in the docket. It's very long and complicated, but I saw an August 10th motion, paper 99, which was denied one day later. That was eventually remanded for a hearing on September 8th, where it was denied the next day. There was a September 30th motion, paper number 163, that as far as I can tell was never ruled upon. And a December 30th, 2021 motion, paper 224, which was heard on January 6th and denied on January 10th, and apparently not appealed. And then you filed a motion on January 14th, 2022, paper 233, which has not been ruled upon yet. Those last two are for transcripts for the appeal that you have timely noticed. And I would suggest to you that upon the disposition of that January 14th motion, if it's not to your liking, that you will want to file an appeal to a single justice court. You won't get me. You'll get the single justice for January or February.
It's unfortunate. Okay.
It's our system. We each get a month. My month is December. So it will go to a different single justice, but I think you will want to do that, assuming you don't get all the transcripts you want. And once that's ruled upon by that single justice, then I think you're going to have to proceed with your appeal based on whatever transcripts you get from the combination of Judge Winnick and whichever single justice you have. So that's the best I can do on the questions you had for your brief. And having said that, I would like to know whether you still would like this court to authorize expert assistance for you.
Yes, I would. Basically, your responses are, the first response, Your Honor, was, I did read the first response that you gave to me, and what it was more advice as to how I could pursue it, it appeared, than it was as to why you feel that appeal bond didn't apply to GLC 227C, which it clearly states in 27A that it does, and that's the glossary for 27C. So I ended up being a little bit confused by that, and what I was actually seeking was more case law of rulings in which something stated that GLC 28G in that ruling did not apply, and that GLC, I believe it's 239. This one's 261, but the other one is, I think, is 269 or whatever, 239 maybe. That the court had used, why that would supersede the indigency statute. Because it seems to sit as a whole, where it says, basically A says this is what's covered, and it says and not limited to as well, and then down below it says that in C how it's referencing back to extra costs as they're defined in 27A, and then 27D is responding to what happens if the court denies or denies or grants the thing. And if it's granted, obviously it's pretty much done. But if it's not, then the proceeding for announcing the right to appeal. In the cases of the second question involved cases where the court repeatedly denies things, but it doesn't deny the actual motion for the waiver itself. It denies something where the waiver is included in the motion, but then doesn't deny the waiver and doesn't actually address the waiver in any way. So it doesn't allow me to go back and say, hey, you're supposed to give me a notice of my right to appeal. And I don't know how to force them to give me the right to appeal. It's an automated process. So if he is not saying you requested the transcripts and you have a right to appeal, it's not kicking off the automated process that allows me to appeal. That was another problem that I was having. Another one that I was having was failures to respond to requests for the waiver. The appellate procedure thing. It's very clear about the no matter how the motion is titled, it can still be considered a motion. A timely filed post-judgment motion. I filed 4 motions to strike during that period that have to do with voiding the motion. If you notice, when the case was filed, it keeps on saying now, when it's filed in the appeals court, that it's 25 Gilbert Street, LLC. They did not bring the case. They're the owners. The owners did not bring the case. The managers brought the case. That's a whole different problem, because technically they don't have the managers did not have standing to bring the case, which is another issue that's been ongoing that the court refuses to address. And in the motions to strike, that's what that was about. It was basically proving that the owners did not bring the case. The plaintiffs have admitted they were not the owners that brought the case. And that therefore there were orders that were placed for parties that were not the owners and that had no standing to make those requests to the court. And so that's where this problem arises, is that they go to the voidness of the judgment, and he has not heard those. And it's really been frustrating to keep, where it says clearly that it's that they don't have to be titled as being Rule 60 or anything like that. They just have to be timely filed and fit the mold of Rule 60 or whatever within NASRAP 4A. I've also been unable to acquire any transcripts at any time. So, I mean, obviously, the problem with that for me is that as an indigent litigant, I'm forced to file these requests for waivers, and the court sometimes takes a very long time, never includes notices that I have a right to appeal.
Mr. Rogers.
Yes.
So paper 149 has the appeal notice. Paper 229 has the appeal notice. The very first one on August 11th didn't have the appeal notice. Which orders denying transcripts?
If you go back to the first time that I appealed, that was back. I'd have to go back and find the orders. I'm not making the argument here. Because I don't have I didn't intend to make an argument here. I was asking for your input as to how I approach it, not asking for you to rule on it. But if you go back, my original time that I had requested them was back in August, when I was requesting transcripts for presenting my arguments in the hearing on the Rule 60 motion, and I asked for transcripts on it because there were problems with the case that I wanted to address, and he denied it without telling me that I had the right to appeal. Then I asked for a motion for reconsideration. He denied it without telling me I had the right to appeal. And the only reason that I found out that I had the right to appeal was I appealed some other issues and also mentioned that he had not provided that notice. And he was ordered by the appeals court, the single justice at that time, to provide the notice and the hearing. So the single justice filed a notice of appeal for me in the court and ordered them to do it. He conducted a hearing and then he complied. And it's pretty obvious that it was intentional, at least as far as I'm concerned at the time. Later on, it's been similar. You've noted that there have been a number of them that were denied without, and it wasn't until he finally, on the third hearing, when I kept on insisting that he comply, on the third hearing regarding the request, he finally complied, and that ended up in your lap in this particular appeal. So there are numerous requests for the transcripts, and I can't get them. This is not the first.
So, what is the expert assistance that you?
It's for basically determining. I've got this other problem of when I come into the single justice and the appeals court, and I'm asking for an appeal, but there's no definition of who has jurisdiction, and I'm constantly being told that the single justice doesn't have jurisdiction. Your Honor even told me initially in one of my prior appeals that he did not have jurisdiction, and then stated you were denying that appeal because you did have jurisdiction. So I'm really the expert assistance that I'm seeking would be somebody that is procedurally capable of telling me when and how to do these things, because if I go through all the effort of generating the appeal, and it's multiple pages long with arguments and references and statements of fact and a number of other things that go into it, it's a lot of effort. And then I get back for the application and the effort, I get back your motion's approved for indigency, so we're waiving the costs, denied. Not within jurisdiction. We don't have jurisdiction. Not denied. We just don't have jurisdiction, and that is trial and error, which is causing me an enormous amount of grief and has wasted an enormous amount of time for me. And I believe that it's resulted in other cases where the single justice may have erroneously stated they did not have jurisdiction.
You said you want the assistance of someone who is procedurally capable of how to do these things. What are these things specifically?
Basically, it would be any procedural processes for submitting appeals, for addressing failures of the court in certain circumstances. For example, not responding to a motion when it says in the appeals court, in the appeals rules, this is what happens if it's denied, this is what happens if it's granted, but doesn't state the other. It's somebody that's procedurally capable of assisting.
I'm trying to write this down, and you're going a little too fast for me.
Oh, I'm terribly sorry, Evan.
This procedural process for submitting appeals. What was the next thing?
It will be for submitting appeals and for addressing problems in the trial court, similar to what I asked you here, where it appears that they're not cooperating to intentionally to frustrate me and to keep me from proceeding. And if someone that was an expert in the process could tell me, no, it's because you're doing something wrong, or no, or yes, it's that you're right. That's not how they're supposed to do it. It would help me, but it's not legal advice. That's purely procedural.
You have in mind who this expert was, or some place where this expert could be obtained?
I do not at this point, Your Honor. My problem is that there is an available service that is this lawyer for a day thing that goes over. But when for whatever reason they don't cover Framingham. So for me to get the same service, I would have to only on Thursdays drive all the way to Worcester and spend the entire day there, which I've done a couple of times. And it's not conducive to getting anything timely done because hearings are often scheduled within a few days. So I can't get the timely questions answered I need. And I've tried using the local place that's Metro West for asking questions on short term, and they basically don't do that. They want you to apply for assistance, and I did that, but I haven't been accepted for assistance because they've got too long of a line of people requesting assistance.
All right. So you want the expert advice of someone who can give you procedural advice about the process for submitting appeals and addressing problems in the trial court. I got that right?
Yes, I think that's pretty much it. And then I'm seeking, which I already did this, as you had advised me before, seeking that the trial court stay execution of the judgment, and that they stall out, don't proceed any further until these problems are resolved. I don't know if I can make that here, but I have made it in another request under 6A, which you would advise me to do. And I did that on Monday morning.
Oh, to another single justice. You've done a
yes.
Okay, I was about to advise you to do that. So it's good to hear that you've done that. Of course, will not come to me. That will come to just.
Yes, that's unfortunate. I do like you, but it's the way it works. So I was sitting at the time, I guess.
We pick months and way in advance, and that's how it works. So,
thank you,
it
Your
comes
Honor.
into January. It doesn't come to me. It comes to the judge for January. All right. So I think I understand what you want and why. And as I promised you, I will get you. Right now, the eviction, I understand, is stayed until at least January 26th by order of Judge Winnick. That's still correct?
Right. Yes, but not the execution, which is it doesn't exact. It's not the same.
But I will make sure that I hope to have a decision for you very shortly, but I will certainly have it before that date.
Thank you so much, Your Honor.
But of course, you should proceed with your motion to stay in front of the next single justice as well.
Yes, Your Honor.
All right. Well,
You've been very clear. Thank you. It does help when clear responses are given. Thank you so much.
All right.
Okay, we're back on the record and we are live on YouTube.
Thank you very much, Mr. Conley. Welcome back. Anyone who's watching on YouTube, you're very welcome. This hearing, as I mentioned earlier today, in accordance with the guidance of Chief Justice Budd and Chief Justice Green, is being held by Zoom, by video conference, and we're very grateful to be able to do that and to be able to live screen this hearing on our YouTube channel. And again, I welcome anyone who's watching. The next two cases and the final two cases will be heard together. Avila versus Dr. Ojikutu, number 21J620, and Avila versus Boston Public Health Commission, number 21J624. These are both on for a motion to stay pending appeal of a final judgment. They're both to stay the same final judgment, which is why they are being heard together. Although I have two separate motions for that, which is why there's two separate docket numbers. Before we get into the meat of it, I think it's rather important that we discuss the final judgment in this case. That final judgment, at least as it's been given to me in the appendices, and as far as I can tell from my review of the case files, it is ordered and adjudged by the court that the plaintiffs named above recover of the defendants named above judgment in summary process for possession of the premises listed above and money damages as follows, and that's $135. So the final judgment for me, depending on how you read it, is certainly for $135 and is either for possession of nothing, as no premises are listed, or is for possession of everything belonging to the city of Boston in favor of Ms. Avila and Mr. Boudreau. I assume, though feel free to correct me, that that is not the judgment that the parties intended to have. It's certainly not what was requested in the complaint. And if I am correct in that, I would like to know what counsel is doing to correct this judgment before it gets before a panel in its current state, which is not really tenable. And I will first, on this question, we're not getting to the state yet. I just want to know how we're fixing the judgment. I'll hear from the city first.
I may, Your Honor, my notice of appearance was yesterday, and really tasked with the idea of addressing the merits, and I may not be as familiar with that judgment question as Mr. Bauer might. So I might, if with your indulgence, have him address that.
Sure. Mr. Bauer?
Certainly, Your Honor. The court is quite correct that we don't think that judgment as it stands is correct as a matter of form. This was brought as a civil action. It was not the judgment requested by the plaintiffs. And as the court can see from the record, the parties jointly requested the entry of judgment, and we simply expected a civil judgment that reflected Judge Bagdoyan's order. We were surprised to get it in this form. We accepted it as it was because we were in urgent need of getting a judgment so that we could appeal. But I agree with Your Honor that it would be appropriate to get that corrected before the court has to hear it, because it is not meant to be a judgment in possession. It's not meant to be a judgment of summary process. It is meant to be a judgment on the plaintiff's claims.
All right.
We have not so far done anything because we've been concentrating on this part of the case, but we certainly would be happy to go back to the court and see if we can get the judgment into a better and more appropriate form.
Okay, Attorney Matou? I'm sorry, I mispronounced it again.
That's okay. I'm used to it, Your Honor. Some of the confusion is because of the way that this case arose, being first a separate summary process case, which is not before the court right now, and a civil case against the moratorium itself. So when the court when Judge Bagdoyan issued her decision on our complaint in the civil case, she initially indicated that in her view, it was a interlocutory order. And that it should be treated as interlocutory on appeal. We had some discussion back and forth between counsel and agreed that Judge Bagdoyan had given us basically everything that we were looking for in the civil action, and so that it actually made sense to treat it as a final judgment. And so we negotiated the terms of the proposed final judgment that we would submit to the court, and then the court entered that final judgment. So I'm a little bit surprised, frankly, to hear counsel for GBLS suggesting that the judgment is defective, given that it's something that we mutually agreed to. But if the court believes that there is a deficiency in the judgment in this civil case, keeping in mind that it's separate from the summary process case, then we of course would work together to fix that.
Your Honor, if I
Sure.
may,
Go ahead.
I did not mean to suggest that we think that this we didn't get the judgment that we jointly asked for. Attorney Matoran is quite correct. The parties jointly asked for a judgment, and we in fact even proposed a form of judgment. It's simply not what we got. So the parties have worked together to get a final judgment. This was just a surprise. And if the court thinks, as I hear you saying, that it really ought to be corrected to reflect what the judgment really was meant to be, we're happy to work with them to get that resolved with the House and Court.
Right. I mean, as things stand, there's really not a lot I can do, because I have a judgment for possession of the city, which if I thought anyone was going to levy on, I would certainly have to stay. So I'm expecting that it will either go down and get what I assume we'll get, which is a declaratory judgment, finding that paragraph 1 of the Boston eviction moratorium is unenforceable. But maybe that's not what it is. But either way, I need you to either correct it or tell me that you're not going to correct it, or that you've tried to correct it and it hasn't succeeded. And I can't really rule it until I get that. So we're going to keep going, because we've got the hearing today. We've got everyone together from multiple countries. So we will keep going. But I'm going to expect you to go and get a judgment that doesn't look like this, or to tell me that you're not either wanting to do that or unable to accomplish that. And I think we will proceed today under the assumption that the judgment I will eventually be asked to stay is a declaratory judgment stating that paragraph 1 of the Boston moratorium is unenforceable. If it winds up being something else, I may need to have a further hearing. We will see what happens. But I think that's the best course of action today, as I think that's the most likely thing that we're going to get when the judgment is clarified. So with that said, I can now turn to the merits of the stay motion. I'm going to start with the city. And before you get into your argument, I would like to just ask, I see the transcripts of apparently, it looks like the transcripts have all been received. Other than the judgment issue, is there anything keeping the appeal from getting assembled?
I believe so, Your Honor.
I don't believe so either.
That's good to hear.
We've spoken with the clerk, Your Honor, several times, and they tell us that they are in the process of assembling it.
All right. In that case, then you may proceed on your argument for the stay.
Right, Your Honor. Thank you very much. And on behalf of the commission, as you stated, the motion before you is to stay the housing court's order holding that the eviction moratorium is unlawful. And we're asking you to exercise your considerable discretion to issue a stay of that order, maintaining the moratorium in place pending an expedited appeal, which I think the parties have principally agreed to pursue. The stay is appropriate in substance, Your Honor, is the need to maintain the status quo due to the compelling circumstances. The health regulation issuing a temporary moratorium as to the eviction in Boston is not unlawful, with the issue at the very least we would submit is of profound significance and importance, given we are in the midst of a healthcare emergency. Now, before going to what the housing court ruled and diving in under the standard for a stay, I think it's important to take a step back and remind ourselves where we are today and some undisputed facts. We're in the midst of a unprecedented surge of infection due to this Omicron variant. Despite vaccination, the infection spread continues. The variant is highly contagious. One person with the virus can affect between 12 to 16 individuals. To give you some perspective, as this motion is pending, back when the first surge occurred back in January of 2021, I'm picking a date of January 9th, the positivity rate was 8.9%. This surge, as of January 10th, 2022, the positivity rate is 31.6%. The number of positive tests per day in Boston is informative.
Is that Massachusetts or Boston or US?
That is Boston.
Okay.
Now, looking at the positive tests per day in Boston is informative. If you go to November, and these are all on a metrics that's publicly available through the Boston Public Health Commission site. But on November 27th, 2021, there were 118 positive tests per day. On December 22nd, 2021, there were nearly 1,500 positive tests per day. As of January 12th of this month, the latest metrics that are available, 2,519. The threshold of concern is 339. Emergency room visits as of January 12th this year, the last available, is 429 per day. Adult COVID hospitalizations per day as of January 12th, 2022 is 694. The threshold of concern is 200 per day. Boston hospitals, it doesn't take any imagination, are stressed. Normal surgeries, as you probably are aware, have been suspended. The bottom line, while this variant is considered not as severe as the original version, it is severe with those with underlying disease, and increase in the number of infections increases stress on the healthcare and healthcare workers and resources, and particularly of the city. And it has been found, and not even really questioned, that evictions have been found to have a significant effect on the increase in the spread of infection. And here, given that backdrop, we're seeking only a stay of the order and maintaining the status quo pending an expedited appeal of this important issue.
So
now to the merits.
One thing that's not very clear to me is what exactly this moratorium does. It forbids landlords from evicting, but as far as I can tell, there's a $1,000 fine is the most you could do under the statute. And it also appears that the city has convinced the sheriff's office and the constables not to levy evictions. And so I'm very curious as to how the moratorium is enforced, what it does, and whether evictions are possible with the moratorium and the way it's being enforced.
Well, I think I'd start in answering your question in that the moratorium doesn't affect the summary process, except where it comes to time to the levy of the execution. And there, we are saying the way it's enforced is we're asking for compliance, the constables, and asking compliance with a regulation, which is supposed to be the force of law. And we would expect that as far as any enforcement, that it would be enforced like any other rule of law, statute, or regulation with the court. And that we expect landlords to abide by it and constables to abide by it. And that any enforcement, if necessary, would be through the courts with a recognition that it effectively is just a stay pending this emergency health concern.
What do you expect judges to do based on the moratorium?
Well, I think they would only be pressed into duty if there was a landlord persisting to levy on an execution or a constable seeking to levy for some reason, and not appreciating that this is effectively a stay pending the emergency and the health concern. I don't think it's any different from any other.
You tell me when. What would a judge do? How would it affect what a judge does in the house?
Well, I think it seems it would be a straightforward ruling that you cannot levy on this execution, and that it's effectively a stay for any levy of execution, and until such time as the emergency has been declared to no longer exist. And that would be the extent of the court's order, and I would assume it would be followed.
Okay.
Here, Judge, the question of is really whether there's a substantial possibility of success using the test that you have for a stay, and where here, particularly, we don't have to show that absolute winner, especially where here the balancing of harms, we submit favors the commission. This is a question of law. It doesn't require any deference. The lower court made the legal ruling that it was unlawful. Now, while the housing court held the regulation was unlawful based on its belief that it was inconsistent with state law, it made no finding or even suggestion that the regulation was not otherwise reasonably related to health concerns. And I would point to the court, the Trinell decision, an SJC case, which I think provides the construct for analyzing the merits of this case, was really not, and the principles announced in that case were not really mentioned by the housing court. And I think they're important to reiterate. The Boston Public Health Commission has been provided broad powers to issue reasonable general health regulations, Chapter 111.31. Its duty and obligation is not permissive, it is mandatory. It is obligated to address significant health concerns affecting the city, including the prevention of disease. And that would be Chapter 111, Section 104. It has to be understood when looking at these issues that the board's experience and expertise is to be given deference by the courts. And we have to understand that this delegation to the Boston Health Commission includes the right to declare an emergency based on health concerns and to take actions to address that emergency. Chapter 111, Section 31 as well. They're given a strong presumption of validity, and the burden was on the appellees here to show that the regulation could not be supported by any conceivable rational basis. There was no showing, Judge, none. And in fact, the way I think you can look at the housing court decision is that it effectively didn't even dispute that. And in fact, I simply can point to you the empirical studies that were before the court that find a direct correlation between evictions and displacement and increased spread of infection. As you can surmise, that evictions force displacement, and the tendency is for tenants to have to live with other family members or others or seek shelters. And in these circumstances, there's close proximity and there's a direct correlation to increase in infection. And I would just point out two studies, Your Honor, one which was cited in the brief, Sandoval, and another one called by Leaf Height, which was in the Journal of Epidemiology, coming out in 2021. The Sandovals, both of those studies compared those states with moratoriums in place and those states where moratoriums had expired to see the effect on spread. In the Sandoval case, Your Honor, 39% greater percentage of infection after 5 weeks, 83% greater infection after 12 weeks. In the line height study, which is entitled Expiring Eviction Moratorium and COVID-19 Incidents in the Journal of Epidemiology, it came to a similar conclusion. 1.6 times more infections at 10 weeks and increased to 2.1 times more infections at 16 weeks. Bottom line, Your Honor, was that this was really undisputed and there was a clear correlation, and the regulation clearly meets the reasonable requirement and limitation. And also there was evidence in studies that show that people who are at risk of being evicted or made homeless already have, in general terms, poor health conditions and access to care. So they get infected with COVID-19. The risk of them being hospitalized or having more serious issues is raised.
So, Counselor, yesterday I heard the state mask mandate, and it has an end to it. It's been extended twice, but it has an end to it, which means that for it to be extended, someone has to actually look and do something. Your moratorium says temporary, but by its terms, lasts forever. So, when does it end?
Yep. Fair question, Your Honor. It was a concern that the housing court also identified. And I would say this, it's not open-ended. It's not forever. It's an emergency regulation. It would last as long as the emergency dictated and as long as the health currents dictated. When would that be? Obviously, there'd be a point in time where the regulation is not serving valid health concerns, that the emergency has passed. And we're all hopeful that that eventually is going to happen. But that should be left to the discretion of the expertise of the board and the deference that courts should give to the boards as to when that would be. Now, that doesn't mean, Your Honor, there isn't some point in time where that somebody might be saying, hey, this has to end. It's not serving any rational basis, but we're not there now. So with that, I think there is an end date. And it's certainly, I would ask only one other point, Your Honor, is I don't believe that in and of itself invalidates this regulation.
Well, so Grace versus Town of Brookline tells me that a 6-month postponement of evictions does not conflict with Chapter 239, but we're going to get there at the end of February. So what's your best argument that you can go longer than that?
Well, you're referring to the Grace decision, Brookline? Yeah, in the Grace, the actually extension in that case was 6 months on certificates of eviction, which could be as long as 1 year on a showing of hardship. So that the time limit or the time component of the Grace case was 6 months to a year. And I think the importance of Grace, which is part of the conflict analysis, and both sides have relied upon it to support their positions, and the court relied on it, saying it's distinguishable because in that case, there was an express delegation to the town to deal with evictions due to the specific housing problems that Brookline was facing. But what the housing court failed to appreciate was that two things, that the express delegation in that case did not mention any fashion the right to impose a 6-month moratorium, which could go up to a year. And they proceeded to address whether there was a conflict with Chapter 239. And as you observed, they found there to be no conflict. And the same logic applies here. I think if there's any concern on time that can be addressed, it is not a means to invalidate this order in its entirety.
Well, how can it be addressed?
Again, I think
I am concerned about the time here. Because this eviction doesn't have an end date, which means that the power of inertia, which is very powerful in government, is in favor of it continuing. So, if you please enlighten me on how the time problem can be dealt with.
Well, it's a hard one. It's an area where placing a time period on it in the beginning is very difficult. because this is a fluid situation. And I think, again, the court should recognize the deference we give to the expertise of the board is to determine when that emergency ends. I suppose one other option, if deemed that way, is that you would, remand for the purposes of determining a limitation based on whatever evidence, scientific or medical otherwise, that would be appropriate. But it's not, and that would be consistent with the severance provision in the moratorium itself. And I suppose that's an option. But just to assume that this is going to be some abuse of power and open-ended, I think is unfair to the commission. And there certainly would be a point in time where maybe a challenge could be made that it needs to end based on empirical evidence and scientific evidence. The commission has no interest in continuing this beyond the time necessary to address this very significant ongoing hardship.
All right, you've had about 15 minutes, if you could wrap up.
Yes, Your Honor. I would just sort of say that I think one of the fundamental flaws, two things, and then I'll close, Your Honor, is the fundamental flaw with the housing court is that it didn't really apply the appropriate construct. You really have to look at legislative intent. Was this statutory scheme intended to preclude any kind of local regulation, particularly a health regulation such as this? And I think the answer is unequivocally there's no such express. And then you get into the purpose. Is the purpose frustrating? And the answer to that, it's not. And that analysis was never undertaken. There's no sharp conflict. And that's why on the merits, we think we have a very substantial chance of success. As to the balancing of the harms, Your Honor, I think it's self-explanatory. The housing court and the plaintiffs state that there was no showing of how the Boston Public Health Commission was irreparably harmed. That's not true. The Boston Public Health Commission is being prevented from performing its mandatory duty to address an emergent and significant health concern, which impacts the city's welfare. The public interest isn't being served by unelected judiciary second-guessing the commission as to a health concern. And stating the obvious, you can't undo an eviction judge. You can't undo the spread of infection. And when you balance those harms, that public interest against what really is an economic claim here, which is otherwise muted a bit by all the federal financial assistance that's available, I think it's a compelling case that that a balancing of the harms indicates that a stay is in order.
All right. Thank you.
Otherwise, we refer to the brief, and I appreciate your patience, Your Honor.
All right. Thank you very much. That was very helpful. I'll now hear, well, first, we will now turn to Attorney Bauer. Before we get into the argument, I saw that in Ms. Watson's case, Judge Malaman issued a new final judgment on December 22nd. It was appealed by your client and appears to be a timely appeal. And Judge Malaman has started the appeal bond process, which it looks like is still ongoing, that he needs more information to make that determination. Do I have that correct?
That's correct, Your Honor.
So am I correct in thinking that no eviction of Ms. Watson is in the off until the appeal bond process resolves itself?
We think, Your Honor, that should be correct. The judge has not said it. And as you've seen, if you've looked at the docket, there have been multiple stages in which he's issued further orders regarding the setting of the bond. But so far, he hasn't actually said that because this is a timely appeal, that she has a right to retain possession pending the appeal from that judgment. And so I agree with you that is the correct result. But so far, Judge Malamud has not said that.
I'm not necessarily saying that's the correct result. I'm just trying to figure out what's going on below.
Sure. No, I understand.
If there is a use and occupancy order or an appeal bond, what do you figure your client's ability to meet those are?
our client does have the ability, because thanks to the Boston Rental Relief Fund, she has funds, and she paid in December, she paid in January. She will continue to pay at the contract rent of $1,300 per month. And while the landlord refused to accept the back rent, Boston Rental Relief Program has a system where the money can be paid directly to the tenant, not for her to take a trip to Las Vegas, but only for her to pay ongoing use and occupancy, and that's what she's doing, and she should be able to continue to do that.
All right, thank you very much. Now you may proceed on your argument on your motion to stay.
Thank you, Your Honor, and I will try as much as I can not to repeat the things that Attorney Wiegand said so eloquently. I'm Dick Bauer from Greater Boston Legal Services, and with my colleagues Alana Gelfman and Gary Klein, we represent tenant intervenor Veronica Watson. It's one of the hundreds and hundreds of Boston tenants that GBLS has represented during this pandemic, many of whom need the protections of the city's temporary eviction moratorium. And as Attorney Wiegand has said, in light of the overwhelming public health need to reduce the spread of COVID, this court should maintain the status quo by continuing the stay of the housing court's decision pending an expedited appeal of this case to a panel of this court or to the SJC. We would ask that you clarify that the stay remain in place for Ms. Watson and the Public Health Commission, and that means that the moratorium is in effect as long as the stay is in place. We would have thought that was a non-controversial point, but landlords have said, well, we are not parties to the single justice proceeding, and we are not bound by the stay. My understanding of the purpose of your stay is to put the moratorium in place, and they are bound by that. And it would help if you would clarify that that's where we are.
Well, how can I do that? Even if I granted a stay, there could be a landlord who has better arguments against the eviction, or a particular hardship that gives them a stronger case. I mean, how can I adjudicate the rights of all those, or all the tenants who aren't in front of me?
Absolutely, Your Honor. You cannot adjudicate any of the rights, and we are not asking you to do that. We are simply asking you to clarify that the purpose of your stay is to undo, for the time being, Judge Bagdoyan's invalidation of the moratorium, leaving things where they were prior to her order, which is that the moratorium was in place and that the city could enforce that.
Carry on.
I want to emphasize a bit with regard to some of the balance of harms, what Attorney Wiegand had talked about before. He spoke in general terms. Some of those points are illustrated by Ms. Watson's personal situation. She lost her job because of COVID. She has high blood pressure, congestive heart failure, asthma, and allergies that put her at elevated risk. And not only are individual tenants, such as Ms. Watson, threatened if they are put out in the street in the middle of the winter with nowhere to go during a pandemic, but the public health of the city is threatened. The Public Health Commission is concerned not only about the individual tenants, but about the consequences of those individual tenants being evicted on the public health of the city, meaning people will end up in shelters, people will end up in hospitals, people will end up doubled up, and that will spread COVID, which will put yet a greater burden on the city, and it will mean more people sick, more people hospitalized, and it will mean, frankly, more people dead. This really is a life or death issue.
Do you have any input you could give me on the timing issue of how long the moratorium lasts and how that affects its legality?
Would repeat, I think, Your Honor, essentially what Attorney Wiegand said. While by its terms, the moratorium continues until the Public Health Commission decides it's no longer necessary, this court needs to assume that the Public Health Commission will carry out its duties correctly and will correctly evaluate the situation on the ground and determine what is needed. And when it is no longer needed, the moratorium will be lifted. And as Attorney Wiegand indicated, if the court thinks there's too much risk of inertia, then the appropriate thing is not to invalidate the moratorium, but to remand it to the commission for consideration of a different system for evaluating what is necessary. And in saying that, I just want to note that that's not for you as the single justice.
No, I can't do that.
That's for the determination of the merits, and for your decision now, which is simply about whether it should be stayed pending an expedited appeal. I think you need to assume that it will be handled correctly, and that during the time of the appeal, there will not be an issue of timing.
You've had about 5 minutes. Anything else?
I want to note the landlords may say that the surge has peaked and that it's dropping. And while that does seem to be the case, the number of cases is still high. This may not end up being the worst, even though, of course, we hope that it will be. Last fall, we thought it might be behind us. We now know that it wasn't. But in any event, the question about what to do is not for the courts, it's for the public health agencies like the Public Health Commission. I want to note that the landlords have argued that somehow this moratorium is enormously broader than the CDC moratorium, and they say it's unnecessary because Chapter 257 essentially provides the same level of protection as the CDC moratorium. Besides the fact that the judgment call about what's needed is for the Public Health Commission and not for the courts, it's simply not true. The Boston moratorium, like the CDC moratorium, excludes tenants being evicted for serious wrongdoing. It protects other tenants. Chapter 257, on the other hand, only protects tenants while their fundings for application are pending. If a landlord refuses to cooperate, the protections disappear, and you can see that in Ms. Watson's case. She was protected by the CDC moratorium until it was struck down. But because Ms. Avila refused to cooperate in getting the available funding, she was not protected by Chapter 257. The landlord promptly got an execution, and it's only the moratorium that has protected her. So the city is not trying to trump the CDC moratorium. It's basically trying to get back to substantially the same place. Chapter 257 is not that place.
Okay. Thank you very much. I'm sorry.
So I wanted to briefly emphasize, as Attorney Wiegand did, the enormous amount of government money that's available, the federal program called ERAP, the state program called RAFT, the City of Boston program called the Boston Rental Relief Fund. This is all spelled out in the affidavits that are in the record. In Ms. Watson's case, it would completely pay the back rent. And even if the landlord won't accept it, it is available to pay, as I noted before, on an ongoing basis. So the harm to the landlords is relatively low. In addition to not being irreparable, the harm to the tenants and to the public health of the city is enormous. The appellant's arguments here have at least a substantial possibility of prevailing on appeal. We think, as Attorney Wiegand indicated, that they are stronger than that, but in any case, it's more than enough to justify the continuation of the stay, and we ask that you do that.
All right. Thank you very much. That's very helpful. I just want, before we continue, I just want to acknowledge that we have lost Attorney Raza, who I understand is calling in from very far away, but she was not intending to speak today, and there are other attorneys representing the Boston Public Health Commission, which she was representing here, so I don't think that is a problem for us. So we will move on to the plaintiffs, and I don't want you to feel left out, so I have a technical question for you as well before we get into the argument, which is that there was an amended complaint that added plaintiffs. And I didn't see any indication that it had been ruled on either way. And the problematic judgment we have only has the original plaintiffs and not the additional ones. Can you shed any light on the status of the amended complaint?
Well, we amended the complaint as of right, Your Honor. So that is the operative pleading in the case. I know that the caption doesn't reflect that, but we made clear in our discussion on when the court heard the motion for entry of final judgment, and everybody was in agreement that the amended complaint is the operative complaint, and the judgment should issue based on the court's ruling, but on the amended complaint.
Hopefully any amended judgment can reflect that one way or another, either by having all the other plaintiffs or by specifying the amended complaint. That would be helpful. All right, that's great. Then you have about 26 minutes. You don't have to take them all. And I certainly would like a discussion that you might be best positioned to inform me about what this moratorium actually does in practice, and whether one can evict someone in the face of this moratorium as a practical matter. But your time is yours to use as you want. That's just something I'm very interested in that I suspect you may be an expert on.
Well, I'll address that right up front, Your Honor. The issue, and Judge Bagdoyan touched on this. What is preventing somebody from evicting? And the answer, Your Honor, is state law. As the court is aware, Massachusetts has a very detailed process and procedures for actually levying upon an execution, and that requires that the constables or the sheriff actually carry out the levy. So we don't have self-help evictions here. A landlord can't do anything unless the constables and the sheriffs are willing to do it. Here, the Health Commission has called for quote unquote voluntary compliance. And they did that by sending out a letter to all the constables saying that, of course, this doesn't apply to you, but we would appreciate your voluntary compliance with this, and not only complying in the terms of not carrying out a levy, but also ratting out anybody who is actually asking you to carry out a levy. So they asked that the constables report if anybody asks them to carry out a levy. And the constables serve at the pleasure of the mayor. So they have a commission for a certain period of time during which they're allowed to act as constables, and that commission can be A, revoked, and B, not renewed. And so all of the constables are under this implicit threat that if you ignore us and you ignore what the mayor wants, then your ability to be a constable in the future are under threat. And we've heard this from constables in the past. It's like, I'm not going to do anything because this is my livelihood. So I can't do anything as long as I'm told that I can't do anything. So I think that's a practical effect, Your Honor, is that it shuts down levies across the board because landlords require the use of the constables or the sheriffs, and they are afraid to do anything. So whether or not there is any direct enforcement carried out other than the $1,000, as you mentioned, which for a small landlord is significant, the practical effect of it is that everything grinds to a halt. So I hope that answers that question.
That's very helpful. Thank you very much.
I did want to touch on a couple of other things that came up before getting to the meat of my argument. Your Honor suggested, and the defendants picked up on it, that the Grace versus Town of Brookline case says that a 6-month delay in evictions does not conflict with Chapter 239. I'd respectfully suggest that's not what Grace says. In Grace, Brookline did what Boston could have and should have done here if they wanted to regulate evictions, was they went to the legislature and they said, we've got an issue here. We would like authority under the Home Rule Amendment to regulate this thing that is otherwise part of the state legislative regulation. And the legislature came back and said, okay, we're going to allow you to do X, Y, and Z. And then Brookline did that. And so the issue with the with Brookline was that they had been given home rule authority. They had not actually exercised it, and then later on they came back and they exercised it. And the question was, okay, so is that in conflict with 239? And the SJC held that given that the legislature gave them the authority to do this, by definition, it wasn't in conflict with what Chapter 239 says. So that's not what we have here. We have Chapter 239 pre-exists. We have no effort by Boston to even ask for home rule authority to regulate in this same area. And instead, the Boston Public Health Commission has unilaterally decreed that we don't care what state law says. We don't care what a housing court says. We are going to declare that nobody is allowed to carry out an eviction in the city of Boston. And that's the fundamental problem with this situation. But before I get there, I also want to address one other technical issue, which is that there actually are two cases here. There is our civil case involving Ms. Avila, and I'm not even talking about the separate summary process case. There is also the case real property management versus Ayat Green. That case was heard at the same time. That was also a challenge to the moratorium. That case was heard at the same time. Judge Bagdoyan issued a decision in both cases at the same time and put the caption for both cases at the top of her decision. In this case, although there is an appeal in both cases, a notice of appeal, the only motion for a stay is in the Avila case. They have not sought a stay in the real property management case. So we have kind of an odd situation here where the court issued an administrative stay in the case that was brought before it to give it time to evaluate whether or not to grant a stay pending appeal. But the same order is actually in effect in the real property management case. And there is no stay. They did not even seek a stay pending appeal in that case.
You mean the same housing court order, not my order?
It's the same housing court order, exactly.
Okay. I thought you said I misunderstood. I thought you meant my order.
That's right. So it's the same housing court order, but there are two separate cases. And so they have sought a stay pending appeal only in the Avila case. They haven't sought it in the other case. So the order is kind of a Schrodinger's order, Your Honor. It exists, but it has been temporarily stayed pending the court's decision in the Avila matter. But it has not been stayed, and they have not sought a temporary stay or a stay pending appeal in the real property management case. So it's kind of an odd situation here, and I think it's important to note that at least as far as the Avila case is concerned, or as the real property management case is concerned, I guess, there is nothing preventing them from actually carrying out the eviction that they were allowed to carry out in that case. And I'm not sure whether or not they have. I'm not counsel in that case. But one could look at this from the standpoint of other landlords and say, okay, I'm not a party to either case, and I have the right to evict. There is no stay in order in effect in my case. There's a stay of her order in the Avila case, not in the other case. So it's kind of a weird situation right now. And I'd suggest that also should factor into the court's consideration of whether it makes sense to continue a stay pending appeal in this case when they have not sought a stay pending appeal in the other case.
Well, I mean, but I'm not sure where that goes. You're telling me that if the order is stayed, that it's practically impossible to evict people. I mean, so how would the eviction happen in that case?
Well,
it might have already happened because no one asked me to stay that.
Right. And I like I said, I don't know whether or not it has happened in that case or not. But a constable looking at this is going to say, well, I don't, they're probably going to defer because they're afraid of losing their commission to not doing anything until they know that they can do something. But the fact that they haven't sought a stay pending appeal in the other case, I think, is indicative of why the court shouldn't grant a stay in this case either. Everything will be set up for an expedited appeal, and the court can evaluate that, either the full appeals court or the SJC at that time. But right now, there just isn't a reason to stay one case and not the other case. It's not a reason to seek a temporary stay pending appeal in one case and not in the other case. And I don't know why they've done it that way, but that's where we are.
Who's they? Who's representing Green, Bird, and Lewis? Barrett.
That was also GBLS, Your Honor, that they came in for, and Mr. Klein in particular came in to argue in that case. I don't know the exact terms of that, whether it was limited representation or not. As I said, I wasn't counsel in that case.
Look that up.
I'm sorry.
Your Honor, may I address that specific point?
Not right now. I'll note that you want to do it.
Thank you, Your Honor.
But putting those issues aside, Your Honor, I do want to get to the merits of this case. The question before the court is initially sort of, what is this? Is this a reasonable health regulation? And the fact that the statute says that the BPHC can implement reasonable health regulations, implies that not everything that the BPHC is by definition a reasonable health regulation. And I would suggest, Your Honor, that this is not actually a health regulation at all. If you step back and you look at the context of what happened and how this moratorium came to be, this has nothing to do with health. The pandemic began in March of 2020. And at that time, the legislature, which writes the laws and can amend and suspend the laws, enacted Chapter 65 of the general laws of 2020. And what that did was shut down the entire summary process procedure. There were no evictions. There was nothing going on in the housing courts. You can debate, and we have debated, whether or not that is a constitutional action under the federal constitution. But what you can say is that the legislature has a statutory right to do that. It can enact statutes governing the landlord-tenant process. So Chapter 65 was implemented, and it shut down everything, and it lasted until October 17th of 2020. And at that point, it lapsed. Now, when that lapsed, the Boston Health Commission did not say, we're in the middle of a pandemic. There are no vaccines. The spread it's spreading like wildfire. People are dying. We have to come in and impose a moratorium on evictions to take the place of Chapter 65, which is no longer in effect. They didn't do anything like that. Okay, so during the period between October and December of 2020, there was no state restriction on evictions. What there was a CDC moratorium, the first CDC moratorium. And that was focused in the CDC's wisdom as experts on the spread of contagious disease. It was focused on economically displaced people. So people who had lost their job, who were not able to pay rent because they couldn't work for a period of time, who met certain income limitations, and who had applied for rental assistance. So the CDC moratorium was in effect in the October through December period. BPHC didn't come in and say, we need to do something, it's a health crisis. In December of 2020, it looked like the CDC moratorium might be expiring. And so the legislature, acting within its legal capacity as a legislature, enacted a new law, Chapter 257. And Chapter 257, it's not an exact overlap with the CDC moratorium, but it basically tries to do the same thing. It focuses on economic displacement, excuse me, and those who are unable to pay their rent, and who at the time of filing the answer or the first day of trial have a pending application for assistance. So the goal is basically to provide enough time for an application to be processed that might obviate the need for an eviction. But that's all the legislature thought it was necessary to do in the midst of this pandemic. And again, there were no vaccinations at that period. The CDC moratorium was then renewed. And you had a double layer then of the CDC moratorium in Chapter 257 in effect for a period of time. When the CDC moratorium first looked like it was going to be struck down or was not going to be allowed to continue once it expired, according to the Supreme Court, the BPHC didn't come in and say, we need a across-the-board moratorium on evictions in Boston because we're not going to have the CDC moratorium in effect anymore. It did nothing. The CDC moratorium then actually lapsed for a few days. And there was some political theater in Washington, and then eventually the CDC came forward and enacted a new moratorium. It was slightly narrower than the previous moratorium, but basically the same thing, focused on economic displacement and inability to pay rent with pending applications. The BPHC didn't come in and say, okay, we need a mandatory eviction moratorium across the board. They did nothing. Then the second CDC moratorium was struck down by the Supreme Court, which everybody could see coming, frankly. And it was at that moment that the BPHC said, wait a minute, we've got a pandemic going on. It's a serious health risk, and we've got to implement an across the board moratorium on evictions, despite the fact that Chapter 257, which was another layer, was still in effect. So why did they do that? And the answer, I think, is pretty clear when you look at the context. It was the midst of a heated mayoral campaign. The current mayor was being attacked by an opponent for not doing enough to protect tenants, given broader social issues.
By current mayor, you mean the current mayor at the time?
The current mayor at the time, yes, acting Mayor Janey, Your Honor.
Just to clarify.
Yes, and acting Mayor Janey was attacked by one of her opponents for not doing enough to protect tenants in this housing crisis. And the very next day, she came out of the BP and announced that the BPHC had imposed this across the board moratorium. So the question is, why did the BPHC do this? Right? Is it really because there is a health crisis that requires an across the board ban on evictions, or is it political? Is it really trying to prevent the spread of disease, or is it simply a political tactic and a tactic to show, yes, we, the administration of the city of Boston, know that there are some real social issues in terms of housing equity and rent rates. And we're doing something to show that we support you. And by the way, can you vote for us? And so that's the context here. So the suggestion that this is a health regulation, let alone whether it's reasonable, a health regulation, is belied by the facts and the context. And I think that the court has every right, in fact, the obligation to look at the context and decide what is really going on here. There is no requirement that the court simply say, well, they say it's a health regulation, so who am I to decide to disagree? And that's especially true when you look at a lot of the rhetoric and the arguments in the briefs. The issue is raised as an issue of the disparate impact of housing prices, the unavailability of housing, all sort of social issues that really have nothing to do with health. And then if you look at the moratorium itself, it talks about the third whereas clause from the end. So it's 1, 2, 3, 4, 5, the sixth whereas clause. says, whereas Boston residents in urgent need of rental assistance resources to prevent evictions and homelessness require additional time to process applications for these funds in order to avoid homelessness and other housing situations that may increase the spread of COVID-19 and cause other public health harms. So the goal supposedly is to provide additional time to apply for housing assistance and to process those applications. But that's what 257 does. So 257 already does that. And the Boston moratorium isn't limited to people who are actually applying for housing assistance or have applications pending or even qualify for housing assistance. It's an across the board ban. So it's not even supported by the supposed justifications for it.
Let me ask you this. There's a lot of case law on reasonable health regulations under paragraph 1 of chapter 111, section 31. But the legislature added a third paragraph that took effect just last year, allowing the Board of Health to declare an emergency exists and then issue an order reciting the existence of the emergency and requiring that such action be taken as the Board of Health deems necessary to address the emergency. There's no case law on that, obviously. How do I adjudicate or judge whether something is valid under that paragraph?
Well, I think that it's actually not that different from what existed before in terms of reasonable health regulations. It's basically saying that the BPHC can do what it needs to do to address a healthcare emergency. But what it doesn't say is the Health Commission can counteract state law. So, it's common for health commissions to issue regulations that don't contradict state law. For example, a health commission can issue a regulation that bans smoking in a bar because there's no law that says that you have to allow smoking. It can issue a regulation saying a vending machine for cigarettes can't be accessible to minors. All of these things it can enact a regulation providing that housing can't be infested with rodents or other vermin. All of those things are things that are reasonably related to health, but don't run contrary to state law. So what we have here, though, is something that runs directly contrary to state law. It says, I don't care what 239 says. I don't care what a court says. A court can order a constable to levy on an execution, which is what actually comes out of the court. The court says, I order you, constable, to do this, to levy on this execution. And the BPHC says, no, you can't do that. We don't care what the court says. We don't care what the law says. You can't do this until we decide sometime down the road that you're allowed to do it again. And so what the Health Commission is allowed to do is enact regulations in the interstices of the law. So they could, for example, do what they did in the second paragraph of the moratorium, which we didn't challenge. And which Judge Bagdoyan explicitly upheld, even though we hadn't challenged it. The BPHC can say, when you're going into a housing unit, you have to give 48 hours notice. You have to give the tenant the ability to be there or not as they desire. You have to wear masks when you go in. Those are all reasonable health regulations, and they don't run contrary to any law. So that's where they're allowed to do this sort of thing. The BPHC could shut down restaurants if they believe that the spread of the vaccine was of the virus was a problem. They haven't done that. They haven't shut down anything in the city. You can get a massage, you can go to a bar, you can go to a concert. All of those things you can do, but the one thing that you're not allowed to do is the one thing that actually has a social component to it, a social problem component to it, which is levy on an execution. And so what they're trying to do is address a broad social problem that really doesn't have anything to do with health. And they're doing it by going directly against what state law says should happen. And so I'd suggest, Your Honor, that's where the problem lies, that they're not acting in the interstices. They're not filling in details about how people act when they're carrying out a levy. For example, you're carrying out a levy, wear a mask. And they're ignoring the fact that the housing courts themselves have the ability and act on that ability to evaluate any particular case on the merits. So, for example, while the Health Commission says nobody can get evicted, period. Doesn't matter how rich you are, how non-minority you are, how employed you are, how many other houses you have, or whether you're going to live on the streets or whether you're going to live in a high rise in downtown Boston. You can't be evicted.
You've got about 2 minutes left before you've matched the time of.
The contradiction with state law brings me to the other issue, which was never addressed by the defendants below, which is that if the Health Commission has the ability to enact reasonable health regulations, it cannot do so in a way that contradicts state law. That's Article 89, Section 6 of the Constitution makes that explicit. Article 7, subparagraph 5 of Section 7, paragraph 7, Section 5 of Article 89 also says that you cannot enact local regulations that are basically civil laws, and the landlord-tenant relationship, the SJC has repeatedly held, falls within that. So you've got a situation where they are explicitly and ostentatiously contradicting state law, and they are doing it in a way that regulates landlord-tenant relationships, both of which violate the Constitution. In terms of the likelihood of irreparable harm to the tenant here, Ms. Watson. Ms. Watson is fully vaccinated and said in November that she was awaiting a booster. So if she hasn't gotten it by now, that's entirely by her decision. So she is fully vaccinated, and she has, as a matter of law, no legal right to remain in that apartment. The housing court has already adjudicated her case and decided she has no legal right. So she can't be irreparably harmed when she has no legal right to be there to begin with. In terms of the harm to the landlords, I mean, aside from the fact that they've suffered 2 years of quote unquote temporary moratoriums of one type of another, the suggestion that there is money available is not true and doesn't apply to.
Counselor, you've matched the time that your friends had, which doesn't mean I won't let you go on, but then you run the risk of me allowing your friends to speak in addition. So that's the judgment call you need to
make. Your Honor, I think I've hit on most of my points, and I think that Judge Bagdoyan made a very detailed decision evaluating the reasonableness of this health regulation, and she came to the correct conclusion. And we'd ask that the court conclude that there is no likelihood of success here, and that there is no reason to continue the court's temporary administrative stay.
All right. Thank you very much. That was very helpful. Attorney Klein, I understand you have something not as a rebuttal, but to give us some wisdom about the Green, Barrett, and Lewis cases.
Yes, Your Honor, I am one of the counsel in the Green case. Ms. Green did not seek a stay pending appeal solely because she has an effective stay in the housing court. At paragraph 3 of the order that Judge Bagdoyan entered associated with the December 22nd, 2021 decision, she directed the clerk to schedule another hearing sometime in January. That hearing hasn't even been scheduled yet. So there is no risk to Ms. Green of an imminent eviction, which is why she didn't seek a stay pending appeal. She obviously would reserve her right to seek a stay pending appeal if it became necessary.
All right. Thank you for that clarification. I want to thank everyone. This has been extremely helpful to the court. I'd also like to thank Mr. Conley, our host and clerk in this case. And most of all, I want to thank our clerk, Joe Stanton, and his entire staff, who have made it possible for us to keep our operations going, even when we're not allowed to be in the courthouse. They've done an incredible job. We've really been ahead of everyone in doing this. And I'm always very grateful for their assistance in that way. Before I close up, I just want to make clear that I expect something to happen about the final judgment, even if that is you all deciding that you're not going to do anything. But I'm not going to issue a ruling until I get some notice from you about what, if anything, is happening on that, or that something has happened and here's the new final judgment. So I will expect to see something from one or two or all three of you about that issue before I will take the next step and issue a decision. So just realize that you're not going to see anything until you tell me what's going on with that. And with that said, again, thank you all one more time. And court will be adjourned until February 1st at 9:30 a.m. on both channels, unless there is a single justice matter that's urgent that is scheduled before then. And also, thank you to anyone who's watching on the YouTube channel.
Your Honor,
Yes.
I apologize for inserting myself again, but would you also be willing to clarify that the administrative stay that you entered remains in effect pending your ruling?
Well, my stay continues until I issue an order. So
Thank you.
that's how it's going to be. All right. So again, thank you all very much. Court's adjourned.
Thank you.
Judge.
Thank you, Your Honor.